central government and the state government. So definitely their role become very crucial, because why I'm saying this, because there are some questions that what is the need of governor and the president when we already have the elected chief minister and the prime minister in the center. And when it comes to the president, people at times says that they are the rubber stamp. So definitely they are not. To an extent, I do accept the fact that they act on the basis on whatever the interest to serve the interests of the central government, but their role is very crucial, because the India country like India, definitely we are the country where we have more tendency towards the center. We have more the central government have the more power rather than the state government, and definitely central government have more weightage than the state government. But in order to protect the interest of both, we need one agent to mediate in between them. So definitely governor act as that agent. So let's come to the point that governor is a part of the state executive. There are state executive like chief minister, council of minister, but the governor is the head of them. Governor is the one who definitely make them to oath, take a oath on the post of the chief minister and the council of minister, respective ministers whosoever being appointed. So he is a part of state executive. He is the head of the state and the council of minister. So like the president we have in the central government, he is the head, and in the state government, the governor is the head of the state and the council of minister. The state executive is very similar to the that of the central executive. In the central level, we have the prime minister and the council of minister, and the president head them. In the state, we have the governor who had the council of minister and the chief minister. Like the center, the state also have the parliamentary form of the government. So we do have the Westminster model, because once we are adopting that what kind of government we should adopt, then we adopted the Westminster model. So Westminster model belongs to the British parliamentary system, and it is the place where Westminster is the place where British Parliament is located. So definitely we have adopted the Westminster model in our states as well. So definitely we will have an elected chief minister in within every 5 years, and then there will be a council of minister after all the elections results are out, and definitely the government will make sure that they saw an oath to it. So they must be the chief minister, and all the minister must work in compliance with the constitution of India. The governors also must work in compliance with the constitution of the India, and if they don't do so, then definitely we have courts in India who will make sure that the constitution is followed and the values of constitution are upheld. So I was reading a metaphor. I think it was a metaphor by the Justice D.Y. Chandrachud, which says that the Constitution act as a North Star. So definitely, whenever there is a dark, whenever you are not able to see the path, then definitely the Constitution will act as a North Star. So what has been said in the chapter 3 of the Constitution with regards to the central executive is to an extent applicable to the state executive as well. If you see that somehow the provision are more than likely same, but there is some kind of exception as well. As in the central government, we do have the vice president post, but in the states we don't have the vice governor's post. So there are some differences, but more than like whatever the power that the president have with regards to the nation, the governor have the same power with regards to the state. Coming to the next point, usually there's a governor for the each state, and this is the provision that we have. But after the 7th Constitutional Amendment Act of 1956, so after that act, it facilitated that the same person can be appointed as a governor of two or more states. And in north and eastern state, mostly it happens they appoint one person as a governor of two or more states, so that because there are some states which are very small, and I think you know appointing a governor is a very expensive task in itself. You have to give a lot of privilege and then immunities, and then there are a lot of things that come with that office. And there are some states which are very less in the population. They have very less, states like Sikkim, if you can see. So definitely the government also think that the governor should be given more population and he should administer more population. And definitely there are two and more states given to many of the governors. The governor of the state plays a multifaceted role. So definitely, I've told you in the introduction as well, as the governor of the state have a multifaceted role. He is a link between the center and the state government. the central government, whatever the decision the central government have, they communicate through the governor only, and the whatever the decision governor takes, and even the council of minister takes, the governor communicate that decision to the central government. So it is the duty of the governor to keep the state, to keep the center informed about the affairs of the state. So it is his duty. Whenever there's a, if the governor is saying that there's a breakdown of constitutional machinery, then he needs to inform the central government, definitely the president, that there is a breakdown of constitutional machinery and we need the uh, a president rule over there. So this helps the center to discharge its constitutional function towards the state, because the center also have the constitutional duty towards the state to see whether the law and order is in the order, whether everyone, whether maintenance is there in the place. If not, then the central government has to intervene on the report of the governor. So the governor act as an agent whenever there is a proclamation of breakdown of constitutional machinery under Article 356. Definitely, if there's a president rule, if there's a breakdown of constitutional machinery, then the governor is the one who rules the state, who take the decision on behalf of the state. And till the time there's no elected government, the governor, if you see the state of Jammu and Kashmir, and the governor Manoj Sinha, it has, and even before that, Satyapal Malik. So they have the long, I think, tenure as a governor without any chief minister. So if you see, recently Mr. Amar Abdullah has been appointed as the chief minister of Jammu and Kashmir, but before that, I think more than 5 years or 4 years, the state was properly ruled by the governor only, or the lieutenant governor now we can say. So definitely the governor roles become very important in such a situation. The governor is formally appointed by the president under Article 155, but in reality, the president appoints them on the advice of prime minister. Definitely, we know that the governor is appointed by the president, but the president is bound by the aid and advice of council of minister headed by prime minister. So, before reading any constitutional topic, we always say, and in legal, we always say that we need to understand that why such provision has been brought into the constitution. Because there was a lot of debate and discussion that happened at the time when such provision and article were incorporated into the constitution. And definitely we need to look down to the constituent assembly debates. So if we see the constituent assembly, the Constituent Assembly fully debated the merit and demerit of an elected versus nominated governor, and finally opted for the system of presidential nomination rather than the direct election of the governor because of the several reasons. So there were debate that happened at that time whether the governor should be elected one or nominated one, or why we should opt for the nominated governor rather than the elected governor. A lot of debate and discussion had happened, and then they come to the point that there should be a presidential nomination sort of thing in the governor elections. So first, a nominated governor would encourage a centripetal tendency and thus promote all India unity. So definitely a governor which is appointed by the central government will definitely tend will be biased towards the center, or maybe have a sort of more weightage towards the center, and definitely that will promote the all India unity. On the other hand, the assembly was apprehended that if the governor, an elected governor, would tend to encourage the separate provincial tendency more than otherwise, and he'll have a very less link with the center. Let's suppose we have a governor which is elected directly by the people, like the chief minister, then definitely he'll have a separate provincial tendency that we have seen in the British era as well. So he'll have a very less link with the centers. So in order to protect the interest of the state and the center state relation, it was thought that it is better to have a governor which is appointed by the center on the that the election that we have, the provision of the election that we have now. So they thought that the nominated governor will be better rather than the elected governor. In second point, in a parliamentary system, the head should be impartial. So the Constituent Assembly also debated this part, that in the parliamentary form of the government, the head of the government should be impartial. But let's suppose if the head of the government is elected directly by the state, then definitely there will be some bias, and he'll not be protecting the national unity, rather than he'll thought more about the interests of the state. But a governor elected by a direct vote of the people would have to be party man. Let's suppose if the governor is elected by or is nominated by the party as a candidate, then definitely he'll have a more bias towards the party rather than the state and the nation as whole. On this point, it was stated in the Constituent Assembly that he should be a more detached figure acceptable to the province. Otherwise, he could not function, yet may not be a part of the party machine of the provinces. On the whole, it would be probably be desirable to have a people from outside eminent in something, education or other fields of life, who would have naturally cooperate fully with the government in carrying out the policy of the government, yet represent before the public something above politics. So the main reason and the line that I have added in this presentation is that because the Constituent Assembly thought that he should be a figure, he should be a more detached figure acceptable to the provinces. So he should be a figure, a detached figure, but it should be accepted by the provinces. Otherwise, he could not function. And he should be someone who is above the party line. And he should act as an agent of the central government. And he should protect the national unity, national interest, and the interest of the state as well as. So that is why the provision of the governor or nominated governor was added in the constitution. Thirdly, conflict might arise between the governor and the chief minister if both were to be elected by the people. For the former might claim to the arrogant power to himself on the plea of his having been elected by the whole state, as against the latter who could be elected by only in constituency, which would be a small part of the state. It was stated in the Constituent Assembly, when the whole of the executive power is vested in the Council of Ministers, if there is another person who believes that he has got backing of the provinces behind him, and therefore at his discretion he can come forward and intervene in the governance of the provinces, it would be really amount to surrender of democracy. So definitely, if there are two heads in the state, one is the chief minister, one is the governor, if both were appointed by the people, so definitely governor will thought that he have the majority of the vote of the state, because the chief minister generally have the election in the constituency. But in case if we have an elected governor, then the governor will have an election to in the entire state. And that, let's suppose there are two parties who will standing as who will make a governor candidate. One is the X party, one is the Y party, and entire state will vote for them. But for the chief minister election, you need a majority government. Then more of more candidate of your party will go to different constituency and ask for the vote. But definitely, then governor will think that he has a majority of the power because the entire provinces voted for him, rather than the chief minister who came from one constituency and his party won the election and he became the chief minister. And then definitely there will be a conflict in the democracy, and the Constituent Assembly stated it may amount to the surrender of democracy. That is why again we have opt for the provision of nominated governor rather than the elected governor. Then the bring governor being only a symbol, a figurehead, there would be no point in spending money in having him elected. Definitely election, the normal election that we have, the general election that we have, it's very expensive process. So the governor is only a symbolic head of the state, is a figurehead, and definitely the constitution gives a cattle bench to the center in the matter of appointment of the state governor under Article 155. The ultimate responsibility to appoint the government rests with the central government. So the assembly thought that it will be very expensive, and again we'll have a lot of politics going on appointing governors back, and then the state will be in forever in the election. So definitely they thought instead of having a direct election for the governor, it should be some different way that we should elect the governor of the state. So we have already seen that why such provision was added into the constitution, and what was the idea behind bringing such articles and the post of governor, and why the nominated governor should be there. So there is an extensive debate in the Constituent Assembly, and I would recommend each one of you, because you guys are preparing for the competitive exams such as the UPSC. So one should go through that. I know that the Bible for you guys is Lakshmi Kant. I have also read that Lakshmi Kant book, and we all do, because Indian polity is a very important part of our competitive exam. But definitely, I'll recommend you to go to Indian Parliamentary website and read the Constituent Assembly debate. It's a very long debate. So I'm just bringing out the chance for you, because in a presentation you cannot read each and everything, but it's a very long Constituent Assembly debate. If you read it, it's very interesting. There were a lot of debate and discussion while bringing such provision. And definitely recently also we have seen a lot of uh, controversies with regard to the governance states. And definitely, even after your exam, if I got the time, I've made the presentation. We do have the presentation with regards to each and every case, whether it is the Tamil Nadu case, whether it is the university case where the governor, chancellor to the state university, SR Bommai case, and what measures can we adopt. It's a very long Sarkaria Commission, Punchi Commission. So there are different commission, the guidelines that we have. Recent controversy in state of Tamil Nadu versus the governor of Tamil Nadu, the recent bill, the recent presidential reference, where the president Draupadi Murmu reached out to the Supreme Court about certain question, because the court have determined certain timelines for the governors or the president with regards to the bill, withholding of the bill, giving assent to the bill. And if we have heard, our former Vice President of India, Jagdeep Dhankar, also raised certain question with regards to the judgment by saying that how can a court order to the president or the governor to give his decision in a time-bound manner when the constitution is silent on it. And it was also called as a judicial overreach by the former vice president. And now also Draupadi Murmu has reached out for the presidential reference. But the problem that I was reading, that the presidential reference cannot overrule the decision that has already been passed by the Supreme Court bench. So let's see how this matter develop. While let's just we'll discuss each and every topic, and I can share this presentation with you all. And in case if any one of you is still preparing for the examination, they can reach out to me via call as well. I'm happy to help you out in whatever way I can. So, as to the term of his office, governor is appointed for the 5 years from the date he entered upon his office. We all know that the governor, the president, vice president, the prime minister, chief minister, the election term has always been 5 years. However, he may resign earlier by writing a letter addressed to the president. This is a very important question because at times we get confused at who is giving a resignation letter to whom. In most of the competitive exam, I've seen this is the favorite question that they have. So please remember the governor resigned to the president, and he may also be removed by president at any time, even before the expiry of his 5 years term. So definitely, let me tell you the instance. Uh, when the India got independent, there was a majorly Congress ruled governments in entire India. So till fourth general election, I think I've written it, till 1967, there was no problem. Chief minister were consulted before appointing any governor for the state. Everything was running smoothly. But what happened after 1967? The regime started changing. There were the different party in the state that came into the power. And then after that, this provisions, these role of governor become very controversial. Be it by SR Bommai case, there are different cases after fourth general election, because till fourth general election there was no such big issues. The chief minister were consulted because they were the same party in the center and the state which was ruling. So there were no issues with regard to the governors. They were very happy with the governor. But after that, it become a majorly controversial provision in the constitution that the governors are biased towards the central government. They act as a proper agent of the central government. They do not listen to the state. Even if you have seen the former vice president Jagdeep Dhankar when he was the governor of West Bengal, the huge we can see tussle between the chief minister and the governor. We can see in Delhi also the lieutenant governor of Delhi and the former chief minister of Delhi. And now, if you can see, there's no dispute between the lieutenant governor and the chief minister because they are ruled by the same party, because they belong to the same party. Although we say that the governor do not belong to the any political party, but whoever is appointing them from the center, and if they align to that ideology, so definitely they work according to that. So although Article 156 3 mentioned a terms of 5 years, the governor does not hold office for a fixed term, but hold office during the pleasure of the president. This means that the governor may be removed any time without assigning any reason. So definitely giving reason for the removal is not mandatory. That why the governor has been removed. So whenever there's a regime change happens in the central government, definitely they try to bring the governor according to their own whim and wishes. So they thought that because the state governor should be according to their wishes, and even after 2014, we have seen there were a lot of governors who were removed from their post. be it Sheila Dikshit, she was the governor of the Kerala. She has been called by the central government. She was removed from the post. The pleasure of the president is not justiciable. A governor whose term has expired may be reappointed for a fresh term. A governor can be reappointed. There's no prohibition in that. He continued to hold office until his successor enter upon his office. This is the normal provision we have with regards to the every post. The office of a governor may fell vacant due to the resignation, removal, expiration of term, or even his death. The president may make arrangement for the discharge of the function of the governor in such a contingency. If such contingency arises, there is a vacation in the post by resignation, removal, expiration of term, even in case of the death of the governor, the president may make such provision to tackle with such a contingency. It is well known that in several cases, the central government has removed governor appointed by the previous government. It is a major, I think, political strategy, you can say. This has normally been done on account of change in the political party in the power at the center. Certain governors removed by the center have challenged their removal in the court. Definitely, there are a lot of court cases that has happened because the governor was removed by the central government. But definitely, in that case, also the court has told them that the president is not bound to give them a reason for the removal because the constitution does not mandate that. Now, in BP Singhal versus Union of India, it's a 2010 case, the Supreme Court has observed, although the president can remove a governor without assigning the reason, the power cannot be exercised in an arbitrary, capricious, or unreasonable manner. So it should not be unreasonable. A change in the government at the center is not the ground of removal of governor holding office, nor it is permissible to remove a governor on the ground that he is not in standing with the policy ideology of the central government or that union government has lost confidence in him. The court further held that while no reason need to be assigned for the removal, the situation or cause for the removal must exist. And the removal can be challenged on the limited ground of malafide, arbitrariness, violation of constitutional provision. So these are the ground where a governor can challenge his removal. The Constitution, however, does not lay down any procedure of removal of governor, nor does it require the president to communicate reason for removal. The position of the governor is thus substantially dependent upon the political climate relation between the center and the state. So in total, we can say that Supreme Court is trying to balance it out, but we cannot do so. But what I have find out while reading this judgment, on the one hand, the court is saying the president is not bound to give any reason or any sort of explanation that why they are removing the governor. On the other hand, they are saying that the removal should not be arbitrary or unreasonable. Reason being, if there's a change in the central government, definitely the government will change the governor, and they'll not say that we are changing the governor because there's a change in regime. They'll definitely give some other reason in the court of law, which will definitely become justiciable. And by today, if not today, by tomorrow, they'll change the governor because the political climate in this country is such that every central government want their agent should be there in the state. While they'll want someone who can oppose them, who can challenge their policy, who will not implement their ideology in the state. So definitely they don't want that. So every central government, and we have seen it since independence and since 1967, when the political climate of this country started changing, there was every government has tried to bring their own governor. We have never seen that the governor of opposition party has been brought the member of opposition party has been appointed as the governor in the state. There are very rare chances of it. So everybody wants their party member or the person who belongs to their ideology should be a governor in the state.